Great. Thanks, Kelly. Hi, everyone. My name's Kate Wormfeld. I'm with the Center for Court Innovation. And just like a brief background is that I was a legal services attorney for many years representing victims of domestic violence in New York City. And so I love getting back together with my fellow legal aid attorneys and talking about all of the system challenges that we face as we help our clients navigate this process. So procedural justice is a topic that I hadn't heard of when I was practicing, but once I learned about it, I recognized not only the ways in which I was already doing aspects of procedural justice, but also ways in which I saw how it could be helpful if we can be more intentional about utilizing some of these principles. So that's my kind of long way of saying that this is like a common sense topic that is going to be familiar to you, but there is a really strong research basis for it. And if we take kind of a more systematic approach and figure out ways of consistently utilizing these principles, it can really help in your practice and help in representing clients. But there, although it's very common sense, there are a lot of challenges to actually being able to deliver it consistently, and we're gonna take a deeper dive into some of those challenges later in the webinar. You are welcome to ask questions along the way. Kelly's going to be monitoring the chat box for me. And there are also going to be a couple of points where I'm going to actually ask you to use the chat box to respond to some questions that I have, because this topic really kind of only works, or a discussion around this topic only works if you all are kind of supplying the on-the-ground information about what's happening for you, what's happening in your work, in your systems, and what challenges you're facing in representing your clients. So I'm hoping, I know it's sometimes hard to get people to participate on a kind of a giant webinar, but I'm hoping that you'll be brave and just chat in, and I promise I won't make you speak, but it'll just be helpful to get all of your perspectives on the work as we kind of navigate this topic. So let's get started. This is about access to justice and procedural justice, and the ways in which we can use principles of procedural justice to support self-represented litigants. And also, I think it will help in terms of the clients that you represent as well. So we're going to explore the research basis around procedural justice, which dates back many years, but it's sort of become a hot topic in the last few. We're going to contextualize it within the family court system. So in other words, we're going to look at kind of the barriers and challenges to being able to deliver procedural justice to self-represented litigants and clients. And we're going to discuss those challenges and identify strategies for client engagement and serving SRLs. I am going to start with just a kind of an introductory case study that kind of illustrates the need for procedural justice. So this was a case study that was done in Washington State, and it was one in which they surveyed juvenile respondents after first appearance and at sentencing. So two different points in the process for these respondents. And the first question that they asked them, the first question that they asked was whether or not they were represented by an attorney. And since they were respondents in juvenile cases, as you can imagine, they were all represented by attorneys, as required by law. But you may be surprised at the answer of how many did not know they were represented by counsel. So 3 out of 10 did not know they were represented by counsel. So they're standing at the table, they're listening to the judge, their attorney is standing next to them, but 3 out of 10 didn't know that they had a lawyer. So it's pretty surprising, I think, but maybe not for some of you. And then the other question was, how many of their release and sentence conditions did they remember? And all of them, you know, as required, were allocated as to what the conditions of their release were, what their sentencing conditions were. The judge explained all of that. But you may be surprised by this answer. 1 out of 3. So only 1 out of 3 conditions did they remember, which obviously poses many problems for, you know, whether or not they're going to be able to comply with the conditions of their release. And then also kind of begs the question, what's happening for these respondents? And these are, you know, some of them are maybe younger teenagers, but a lot of older teenagers. And so what's happening for these, you know, young people that they're unable to remember what the judge is telling them? And then, you know, if you can think about sort of what you know about adults who are accessing the system and whether or not you think that this would be similar for a lot of folks you've come into contact with. So just a little warm-up exercise. I want you all to consider a time when you had to navigate a government agency or bureaucratic process. So forget about our family court system, but just any kind of system that you had to navigate, the IRS, the cable company, the DMV, whatever it is you can think of. And so you were the layperson and someone in a position of authority failed to explain something important to you, and sort of what your experience was with that process. So think about your examples. I'll give you mine. I was dealing with the IRS a few years ago. I had a babysitter who was taking care of my kids, and I wanted to do the right thing and pay my babysitter on the books so that she could have Medicare and Social Security taxes paid for her. And it was so complicated to be able to do that, as you can imagine, because they make you kind of act, they sort of treat you like you're a business because you're employing someone. But of course, I'm just an individual, and you know, don't have other employees or any kind of system in place to pay an employee. And so it was very, very complicated. And after the end of her employment, I got a tax bill of $1,000. And I was really surprised and didn't understand because I thought I'd been paying all along, and I couldn't figure out, they just sent me a notice that I owed $1,000. I couldn't figure out why that would be or what had gone wrong. So I spent many, many, many hours on the phone with various representatives from the IRS trying to understand what I owed, whether I owed it, what it was based on, and how to resolve the issue. I would wait on hold for sometimes half an hour to an hour and then be told that I was talking to the wrong person and that I had to talk to somebody else. I had a really hard time understanding what they were explaining to me, even though I have a law degree. Our tax system is really complicated, and I am not afraid to admit that I had no idea what they were talking about half the time. And it took me about 6 months, and it turns out I didn't owe the $1,000. It was a mistake. But it took 6 months for me to figure that out by finally getting somebody on the phone who was able to explain to me kind of what had happened, and what I needed to show them, what I needed to document in order, you know, to figure out what it is that I owed. And so after that whole experience, you'd think I'd be happy that I didn't owe $1,000, right? But I was just really deeply, deeply annoyed, you know, just really frustrated with the process. I never want to have to deal with the IRS again. You know, all of the feelings that you can imagine that I had, that I'm sure you all are thinking about with your examples. So these are just some other examples. Long lines at the DMV. That's me sitting in that chair, the skeleton on the phone. Your call is very important to us, so please continue to hold. You know, me kind of growing old as I waited for another IRS representative to get on the phone with me. And so the question is, how do you wish you had been treated? So think about that example that you have, of experience you had. How do I wish I had been treated by the IRS? I wish that the person I finally got on the phone had gotten on the phone with me, at the beginning. I wish I had gotten a communication that didn't just simply give me a bill, but maybe provided me with some explanation about the deficiency in the tax. And then I wish that person who had gotten on the phone with me had explained, what had happened, what I owed, why I owed it, and then what I needed to do to resolve the situation. And I needed that person to explain it to me in a way that I could understand, not, use it, not like citing to arcane sections of the tax code. If all those things had happened, even if I had owed the $1,000, I think I would have had a much, much better view of the IRS. Because if it turns out I owed it, but I understood why, and someone had explained it to me and had treated me respectfully, then I might have had a very different experience and been able to accept the outcome. I'm gonna stop for a second because it looks like there might be a question. Oh yeah, so someone is sharing that they had a similar experience with the IRS, not surprising, submitted a power of attorney form to represent a specific client, but they rejected the form and wouldn't tell me what was wrong with the form. To their credit, they were following identity theft procedures, but it was very catch-22. Right, I mean, so there may have been a legitimate reason why they rejected the form or why they could not tell you certain things, but of course there are always ways for folks to communicate. And we can think about examples of this from our, family court practices. There are sometimes things in the law that are just, they are what they are, and there's nothing you can do about them. But the way that you take the time to explain it to clients or explain it to self-represented litigants can make a really big difference. And so another comment is that this is what we see with SRLs trying to file for divorces in Philadelphia and trying to get info from the clerk's office. Right, so I purposely brought up an example that had nothing to do with family court practice, but knowing that it would bring up lots of examples from your practices as well. So absolutely. Okay, so what do clients or what do self-represented litigants want from their legal representation and from the system generally? Do folks want to chat in here and just, throw out some things that you think folks who are accessing the system, what do they want out of it? They want to be heard. Yep, absolutely. They want to tell their story, right? We hear this from clients all the time, right? They want their day in court, or at least they want you to know what it is that's happened to them. Someone else says they want to be treated with respect. They want fairness. They want results. Absolutely. Anything else? They want to understand the process, right? I mean, that is one of the most frustrating things for folks when they're accessing our system. They want to feel that they're important, right? I think that's similar to being respected. Feel like their case is not just a number in a case file, but actually something that's important to somebody. Yeah, all good stuff. So another answer is procedural justice. You all have just kind of hit on the main tenets of procedural justice. I told you it was common sense. A lot of it is common sense. But just to give us kind of a working definition, the perception that you're treated with respect and your concerns are taken seriously. That is due process at its core, in its essence. That is what procedural justice, also sometimes called procedural fairness, is. And what the research tells us is that when procedural justice is present, it promotes compliance, so more likely to comply with court orders, and engagement, more likely to come to court and access services and show up, which we know can be one of the biggest challenges representing clients, particularly domestic violence victims. That's one of the really, really big challenges. So the concept is that winning isn't everything. Outcome favorability is the notion that people like to win. We know that, of course, people like to win, but outcome fairness is the idea that people can accept an undesirable outcome if they perceive the process as fair. So the example, my IRS example, if I had owed $1,000 because somehow along the way I hadn't paid everything I was supposed to pay, but someone had explained that to me, treated me respectfully, and it made sense to me, and it was fair and a neutral policy, then I would have been okay paying that $1,000. And then the flip side is that even though I found out I didn't owe the $1,000 because the whole process had been so opaque, I was actually less satisfied than if I had actually owed the money. So procedural justice is the idea that people really do value the fairness of the process that led to that outcome. And we've got some chat here. Sorry. As I figure out this technology. Just someone else mentioned something else. To be represented by an attorney who is in their corner. Absolutely, legal representation is really, really huge for procedural justice. And of course that has to do with someone being able to be heard, right? And also understanding the process. If they have a lawyer, it makes it so much easier to do that. And of course, that's why this is such a good topic for figuring out how to better serve self-represented litigants, because they don't have access to attorneys. Absolutely. So this is my one research slide. I'm not a researcher, so I'm not going to spend too much time talking about the research. But this is kind of a seminal slide from Tom Tyler, who's a professor at Yale Law School, who's kind of the procedural justice guru. He's been doing research on procedural justice since the 1970s. And as you can see from this study, the green bar represents procedural fairness, and you can see that 71% of the people surveyed felt like the most important thing was that the process was fair, as opposed to 19% that the outcome was favorable, or that the outcome was fair. And there's lots of research on this, by the way, which I'm happy to provide if folks are interested. A lot of research in family court about this. There was a research study out of the family court in Hennepin County in Minnesota, where they had two different groups of people, who one of which was listen to a judge explain everything about the decision in their case, and then the other group that a written decision was issued, but nothing was explained to them. And as you can imagine, the group that had the judge's decision explained to them and were given an opportunity to ask questions and understood what was going on, indicated that they were far more likely to accept that outcome, to comply with the court's decision, and generally viewed the process as a favorable process. So out of that research, out of all of this research, there are a lot of elements of procedural justice have emerged. These are the top 5. You all have mentioned most of them already, but treating participants with dignity and respect, ensuring that participants understand the process, giving participants a chance to be heard, that they have a voice, ensuring that the decision-making process is neutral and unbiased. This is a tricky one, which we'll get into when we talk about our challenges. Of course, there are aspects of the system that are not neutral and are not free from bias. We know that there are a lot of systemic biases, both conscious and unconscious biases, that can influence decision-making. And what this element is, or this principle is really about, is how folks are perceiving the process. So it could be that the system is not fair, and not necessarily neutral, but if you or if someone in the system is helping to explain what's happening or helping to mitigate whatever it is that's unfair, then that can really help people's perceptions of fairness. And then the fifth one is helpfulness, which is really a key one, particularly when it comes to thinking about how to serve self-represented litigants. So thinking about all the ways that the system can be more helpful to folks, and is actually not only going to actually be helpful, but also make it more likely that they're going to come back to the court, view the court as a resource, which is just, we know, is so key. So now I'd like to invite you to use that chat box again, and share some examples from your work that incorporate the elements of procedural justice. Some examples from the court that you've seen. It can be examples of judges you've seen. It can be examples of court staff, or it can just be examples that you can think of that you've utilized, and maybe you didn't think of it as procedural justice, but you found these examples to be helpful in your work. While you all are chatting, or typing into the chat box, I'll share an example from my own practice. Again, before I knew what procedural justice was, something that I have kind of reflected back on is that the cases that I had that were sometimes the most challenging were the outcomes weren't so good for my client. Maybe they weren't getting what they wanted from the judge. They were looking for custody, but there were challenges to them receiving custody, ability to take care of the kids, those kinds of things. But those were the cases that I actually found myself taking more time and explaining exactly what was happening, because the outcomes were not what we wanted them to be. And I found that in those cases, my clients actually were much more satisfied with my representation than the ones in which I was kind of winning, but not really taking the time to help my client to navigate the process. So I thought to myself, oh, well, we got a good decision from the judge, so everything's fine. But then sort of realized that my client maybe didn't even know that that was a good decision, or didn't fully understand the decision, or were having other issues that I wasn't kind of taking care of because I felt like the case was going well. So it's kind of an interesting dichotomy. So we've got a comment here. One of our judges explains the PFA process every single time to the litigants before her. By the way, this is from Susan Pearlstein from Philadelphia Legal Services. Goes over the procedural history, et cetera. It takes forever and is sometimes frustrating because there are often continuances, but it does help litigants feel like they understand what's happening and what their choices are. Yeah, I mean, that's a really great example of procedural justice. And of course, judges are really, really important players in delivering procedural justice. And one of the things that we often hear from judges is exactly this, that it takes too long. When I train judges on procedural justice, they will sometimes groan and be like, do you know how many cases I have? There's no way I can take all this time to explain everything or whatever it is. But what we found from judges who are really utilizing these principles is that ultimately, when you explain everything up front and you make sure that people understand what their choices are, their case is going to go a lot better. So it might seem like it's taking time up front, but actually is conserving resources down the road. And also thinking about how to do it consistently so that you're not necessarily taking so much time. A lot of judges have scripts for how they're going to explain things. And so it becomes very routine. And then that also really helps in terms of biases. There's research that says that if you're consistently explaining the same thing every time, then you're less likely to, treat one case differently from another. Anybody else have any examples from their own interaction with litigants?
Kate, this is Kelly. While we're waiting for anyone else to respond to your question, I'm going to launch the first of the questions that need to be answered for attorneys to get a substantive CLE credit for this webinar. Please respond now. You'll have 2 minutes. Thanks. You can go ahead, Kate. I'm sorry.
Oh, okay.
Sorry about that.
I'm looking at the poll on my screen. That's why I paused. Okay, so feel free to chat in at any time with some examples from your work, but I'm going to just share kind of some national themes of how, again, common sense stuff, but how, how folks are using principles of procedural justice in their work. So thinking about this principle of respect, introducing yourself and explaining your role. This is something that I think folks take for granted, is particularly important, I think, with court staff. But it's amazing how often litigants are interacting with somebody in the system, but they have no idea who that person is. It could be a lawyer, it could be a clerk, it could be, a parking attendant, and they really wouldn't know. And so that kind of leads to all kinds of issues, right? Like asking the clerk for legal advice or asking the parking attendant how to file something. So introducing yourself and explaining your role seems simple, but is super important. Explaining delays. So, we talked about how there are things about the system that you can't change, and delays is definitely one of those aspects that you're not going to necessarily be able to change. But if you explain the delay to a litigant, it's much more likely that they're going to feel respected, and also just, having their expectations managed. Other things like helpful information about parking or transportation. There are a lot of barriers to folks accessing the system, and if you can help them navigate in any way, that's gonna really help overcome some of those barriers. And then acknowledging difficult prior experiences with the process that led to perceptions of unfairness. So again, procedural justice really is all about how litigants are perceiving or experiencing the process. It's not necessarily how things actually are. So difficult prior experiences could be absolutely what happened, or it could be sort of how they perceived it. Either way, if we can acknowledge those experiences, it's going to be much more likely that they're going to have trust in the process going forward, or think to themselves, maybe this will be different, or maybe this person is actually going to help me this time. So we've got comment in the chat box. I had the chance to represent a client on death row in a post-conviction capital case. The basis of the appeal was that trial counsel, which he paid for, was ineffective and merely showed up for trial without any preparation. Our legal team represented him in a week-long PCRA hearing for which we were well prepared. The client did not get the result he wanted, but finally having competent counsel was at least something, right? So it may not have worked out, but that client's experience with the process, or their willingness to accept the outcome after having a legal team that, represented him or her zealously, it makes a huge, huge difference. Whereas having a lawyer who, barely shows up is going to taint anybody's experience, regardless of what the outcome is. So the principle of understanding, as you can imagine, these are some of the things that can promote understanding for folks. Asking litigants what questions they have, not even just saying, do you have any questions, but actually saying, what questions do you have, assuming they will have questions, and that it's okay and they shouldn't be afraid to ask them. I heard a judge do that once, and I thought it made a really big difference, that small tweak in how that question was asked. Let's review what you'll need to do next. You know, for folks who are navigating our complicated system, with all kinds of barriers to access, really making sure that they understand what just happened. So those young people who are standing before the judge and only remembering 1 out of 3 sentencing conditions, what they needed, and I actually think that they have enacted some changes in the court in Washington where that study was conducted, was to have somebody afterwards actually sit down with them, not in the presence of the judge, not under the pressure of, you know, being at a sentencing hearing and all that that entails, but somebody who's one-on-one, who's kind, who's respectful, who's explaining things in lay terms, and reviewing what they need to do, what just happened, and what their next steps are. This makes a huge difference to promoting understanding and helping them to navigate that process. Materials written at or below 6th grade reading level, considering English language proficiency. You know, someone might be speaking English, but that doesn't mean that they can read it fluently. And that's really important to understand, both when you're representing clients and also when you're thinking about ways to structure services for SRLs. And then explanations of rules and orders. There's so many barriers to litigants understanding what's expected of them. You know, and we'll talk about those challenges a little bit later, but having a way to explain those rules and orders in different ways, you know, with easy to read materials, with, you know, one-on-one explanations, that's going to be critical to how folks are experiencing the process and what they're understanding. In terms of voice, you know, really giving folks the opportunity to explain their situation. I know that I was guilty of this sometimes representing clients. I had been doing it for so long that I kind of felt like I knew what was happening even before they said anything. Like, I'd read the filing, I'd kind of be like, all right, I know what this case is all about. But really knowing, really understanding that the client or the litigant is the expert on their situation, and that and if you actually invite them to explain their situation and give them an opportunity to tell their story, it may take a little bit more time, but you may find that there are things that you weren't considering or that didn't come up in the pleadings. And, you know, similarly asking that question, what else would you like me to know? And then client surveys are something that courts are using increasingly around the country to assess not only procedural justice, but, you know, all other aspects of the system and how the system is functioning and how clients are experiencing it. So having user surveys, you know, either in your legal aid offices or making suggestions for courts to have them as well. So not only is this giving litigants and clients a voice in, you know, how this process goes, but also valuable information for how to improve that process. And then neutrality, explaining the decision-making process is the obvious, you know, having transparency around that. But sometimes policies are not neutral. They're not the same for everybody. But there may be reasons for that. So if there are differing policies, like there could be differing policies for custodial parents and non-custodial parents, payors and payees, you know, there may be reasons why the system works a little bit differently depending on the circumstance, but explaining what those policies are goes a long way to reducing the feeling that people have that things are unfair. Explaining the order in which people are heard. This comes up a lot in courts because sometimes courts are calling cases in what seems like a opaque or unfair way. Maybe they're calling cases that have attorneys first because those attorneys need to get to other parts of the courthouse, you know, or maybe there are other cases that that relate to that case, or whatever it is, or maybe they're waiting on, you know, reports or any number of things. But explaining it, you know, similar to explaining delays to people, really goes a long way to making people feel like the process is not rigged against them, that it's not unfair, that there is a reason why the court is operating in that way. And then helpfulness, I always like to say that helpfulness really is all of the above. If you're doing all these things, you're being helpful. But of course, providing referrals and assisting with other matters. I know legal aid offices are increasingly treating clients in a more holistic way. But when we think about self-represented litigants who come into the courthouse with one issue, we know that there are probably 10 other issues. So figuring out how to assess for those needs and how to provide the supports and resources and interventions that can help folks, you know, deal with all of their legal issues or other social service issues that could be barriers to resolving or addressing legal issues. These are really, really helpful things to consider when thinking about how to structure services for self-represented litigants. These are examples from courts around the country of, you know, what procedural justice looks like visually. So, you know, I know that you all aren't in control of signage in the courthouse, but this kind of just gives an illustration of how to promote procedural justice in this kind of visual way. So you'll see this is actually from the Red Hook Community Justice Center, which is a Center for Court Innovation project in New York City. It was designed to be user-friendly, to let people know that their case was important, that someone would be with them shortly, clearly laid out what the rules are, so that folks know when they get into the courtroom what's expected of them, so they don't just get yelled at by a court officer, and clearly marking the courtroom and where it is somebody is supposed to be. This is from the family court in Maricopa County in Arizona. It's in the clerk's office, and there's a sign that says, "We'll be happy to help you if we can. As we must be fair to everyone, we're allowed to help you only in certain ways." So what the clerk's office in Maricopa County realized is that the litigants didn't understand what clerks can do. So that goes back to, you know, people understanding your role. So they were getting a lot of questions that would have required them to give legal advice if they were answering those questions. And then people would get frustrated when they said they couldn't do that. So they thought if they put up a sign, not only saying the things that they couldn't do so that people understood that they weren't just being unhelpful to that person, but, you know, this is something that applies to everyone, but also saying what they could do. So this is the sort of the positive side is we may not be able to give you legal advice, but we can do all these other things. And here's a list of what we can do, what we can't do. And this really helps to manage expectations. This is from the court in Alaska. And this is really like a pledge of procedural justice, a pledge of fairness. And this is in the entryway of the courthouse when folks first walk in. This pledge of fairness, including the opportunity to be heard, the chance to have the court process explained, and the right to be treated with respect. The judges and staff therefore pledge, we will listen to you, we will respond to your questions about court procedure, we will treat you with respect. So just the tone that sets as soon as you walk into a courthouse, that maybe this won't be what they expected it to be, that this might be a helpful place, and they might be willing to view the court as a resource. This is the full pledge of fairness, and you can see at the bottom, it's in 3 different languages. They surveyed the most commonly spoken languages other than English, and translated the pledge of fairness into those languages, again, right in the entryway of the courthouse. And so if you are walking in there as somebody who doesn't speak English, who has different cultural considerations than others who are accessing the system, you immediately feel like this is a place that's inclusive and will treat you with respect. So now we're going to turn to, this is kind of all easier said than done, right? Being respectful, treating people nicely, the resistance I always get, particularly from attorneys, which I completely understand, is like, really, is this going to make a difference? Like, we just have to be nice to people, and like, we are nice to people. This is insulting. I hear lots of stuff like that, which I completely understand. And really what this is about is, yes, we know what the research says about treating people with respect and allowing people to be heard and all of that. And we know that you're doing that already. And we know that most system players are doing those, for the most part, that's what people are already doing, except that there are things that get in the way of the way that clients and litigants are experiencing the process and experiencing or perceiving the system. So individuals may be attempting to do certain things and treat people in a certain way, but there's all kinds of things that get in the way. So the first example is public perceptions. Before folks even walk into your office or even walk into the courthouse, they are dealing with their preconceived perceptions of the legal process. So what we know is that U.S. crime rates have been steadily dropping for the last 20 years, but confidence in the justice system has dropped by over 32% in the last 10 years. And just note that experiences with any part of the system influence perceptions of every other part and of the system as a whole. So everything that we're hearing about in the news in terms of police departments and people's experiences with the police department, they could have a negative experience with police and they walk into the courthouse door, and that's going to be influencing how they're interacting with the family court system as well. And so misinformation about the justice system is widespread, as well as accurate information about the justice system, right? People have had really bad experiences. We talked about these systemic biases, all kinds of individual conscious and unconscious biases that play into decision makings and the way folks get treated. And so all of those things are going on for folks before they even walk into the courthouse. So Tom Tyler, the professor from Yale, says that we should treat each encounter between citizens and the police courts and other legal actors as a socializing experience, a teachable moment that builds or undermines legitimacy. So something else we know about the research on procedural justice is that when procedural justice is delivered on a consistent basis, that this actually helps build public trust. So it can sometimes be case by case, but when we overall create a system that responds to people in more thoughtful ways and more consistent ways and more helpful ways, then that's actually going to improve general trust in our system. So we talked a little bit about bias as well, and this is a whole other topic, so I'm not really going to get into implicit bias, but just as a kind of placeholder for you, we know automatic associations between groups of people and stereotypes about those groups impacts our interactions unknowingly. And so we know that training is needed, but training is not enough. So we need other strategies on implicit bias and how to be more culturally responsive. You can go to the Court Innovation website for more information on implicit bias, but I encourage much more training and awareness raising around bias. And then I think I also mentioned that, interestingly, when folks are utilizing principles of procedural justice, there's actually research to suggest that they are less likely to be acting on biases. And one of the reasons for this is that you are treating each case like an individual case, because you're listening to folks in a different way, you're giving them a voice, but you're also treating them consistently. You're developing strategies, standard strategies for how you're interacting with folks, which makes it less likely that you're going to be acting on any implicit bias. So the third example is trauma. And you all know this very well, but navigating multiple systems can be anxiety provoking, even under the best of circumstances. I know that I was very, very triggered by my experiences with the IRS. It was very anxiety producing for me. Every time I got on the phone, it just felt like terrible and awful. And I am, not somebody who has experienced a great deal of trauma in my life. But so even without a history of trauma, navigating multiple systems is very difficult. And then, of course, we know that litigants in our system have experienced high rates of trauma as a result of domestic violence, poverty, oppression, system oppression, that folks who are accessing our systems who have maybe been dealing with various symptoms since they were children. Welfare systems and child welfare systems and all kinds of ways that government has intruded on their lives. Symptoms of trauma can, of course, be triggered by a confusing or overwhelming process, which makes it difficult for them to explain to you important things about their case, or difficult for them to understand what it is that you're explaining to them, or what it is they need to know in order to navigate the system or move forward with their case. And so litigants may not be willing to engage or able to engage or access services or comply with additional supports that are offered if they are kind of unable to process what's going on.
Kate, if I could just interrupt, I'm going to launch the second of the CLE credit polls. If you could please respond to this. Thank you. And you're free to go ahead, Kate.
Okay.
Thanks.
So the fourth example is education and expertise. So I've got these big stop signs around Latin and Legalese. I don't know why our court orders still are written in Latin or have Latin terms in them. It's been a dead language for, several years now. And yet it's still contained in a lot of court documents. So this is crazy and needs to be mitigated. It needs to be eliminated, or if, it can't be, if you don't have the power to eliminate it, you can mitigate by finding different ways of explaining things to people. But what I try to remind people, and I do this training for judges a lot, is, even if we all have high levels of education, obviously, because we're lawyers. But even if you remember what it was like when you first started practicing, it could help a little bit to get into the shoes of litigants, particularly self-represented litigants. I remember the first time that I walked into family court as a young attorney. And I had a client with me and a case, and I was appearing for the first time, and I had written like several pages on my legal pad of arguments to be made. I'm dating myself because this is before laptops. I was still using a legal pad. And I was really prepared, and I knew my whole case backwards and forwards. And as soon as I got before the judge, she wouldn't let me speak. And instead, she started issuing temporary orders using all kinds of acronyms. So she was, she said she was ordering a COI and ACS, and you all might not even know what these acronyms mean because we practice in different jurisdictions. And I had no idea what she was saying, and I was too afraid to interject or to ask for clarification. And so I just kind of like took notes and picked a new court date. And then I went back to my office that day, and my supervisor asked how things had gone. And I said, not well. I have no idea what she just did. And I showed her my notes, and she explained to me what had happened. And it was like a terrifying experience. And I was a lawyer. So imagine, how my client would feel, particularly if my client had no lawyer at all. I was practically no lawyer, but I was better than nothing, because I was at least able to explain things to her after the fact. So this is just a reminder, and I say this to judges all the time. Just imagine, when you first started practicing, you are now an expert in everything that's happening in this courtroom. You are the most expert person in the room. And so slowing down and remembering that nobody else is as expert as you are. This is just a quick one. I'm going to read this and you can follow along. According to research at Cambridge University, it doesn't matter in what order the letters in a word are. The only important thing is that the first and last letter be at the right place. And this is from a study on expert versus novice brains. And what it demonstrates is that because I am fluent or expert in the English language, I don't actually need all of these letters to be in the right place. I can kind of infer, or I can tell what the meaning is. But if I am somebody who English is not my first language, or I have a lower level of education, this is going to look like gibberish. So kind of remembering another way of putting yourself in someone's shoes. So that's a lot of challenges. And I'd love to hear some challenges from you all. And I'm gonna give you a few minutes to type in some challenges to the chat box, some specific things that you're seeing in your work, in your systems. And while you're doing that, I'll just go over kind of, so what's in it for you? Why aim for procedural justice? Why should we be doing this? So as I mentioned, increased compliance and victim safety. Folks are more likely to comply with court orders. Victims or survivors of crime are more likely to view the court as a resource and access services. Decreased emotional distress and re-traumatization by the system, which in turn makes our jobs more easier, right? If our clients are not being re-triggered and are able to navigate the system. Increased sense of empowerment, agency, and control for litigants, which of course then makes our jobs easier. Families accessing services and support, mutual respect and trust between practitioners and clients. This one is, I think, worth just sort of highlighting. We haven't talked about this before, but something that I remember from my practice, I had a client one time who was really unhappy with something that had happened in one of her court appearances, and she had agreed to something in court. She had agreed to a temporary access schedule for her children. And then later that day, she called me up on the phone and started screaming at me that she really didn't want to agree to it and that she felt pressure to agree, even though we had discussed it at length, in the courthouse, and that she was very unhappy with me. And I was immediately kind of triggered and angry at being screamed at. And so I didn't deal with it well. And I started yelling back at her and that she couldn't talk to me that way. And you can imagine that whole interaction didn't go very well. And then what I realized is all of the things that I might have done differently to avoid that, which is that even though she had agreed to something in the courthouse, that she may have felt pressure that I didn't see. So just by being in the courthouse, by having to appear before a judge, by the fact that her ex-husband, who was also her abuser, was present, all these things contributed to her to agreeing something that she later then regretted. And so I started changing the way that I worked with her, and really actually worked with all of my clients, which was not to do my very best to avoid agreeing to things in the courthouse. Making sure that I was having those kinds of conversations at length in my office when it felt safer for clients to consider all the options and really tell me what it is they would be willing to agree to ahead of time. So this isn't always possible, but whenever possible, I would try to do this. And then as a result, my relationship with that client became so much better. So it was so much easier for me to then deal with her, to sort of have those strategies, which really are procedural justice strategies. And then the final thing is increased trust in the system. So we talked about that a little bit, but all of this is also something that can improve case outcomes, makes it more likely that folks are going to come back on violations, makes it more likely they're going to comply with whatever the access schedule is, or the order of protection, or whatever it is. All of these things contribute to that type of outcome. And we've got so Susan chatted in that a big challenge is getting court staff as well as judges to understand these ideas. Something that she thinks we can do is to try to create more SRL friendly info with easy to read and understand language about different aspects of the court process. Yeah, I mean, anytime you can, it's really helpful to have judicial leadership around procedural justice, but of course, anything that you all can do as a legal community to help create materials and increase access for self-represented litigants so that they're not relying on busy judges with busy dockets, who we know some judges are good at this and some aren't. And we can't always control that. So definitely thinking about the ways that you can support whatever it is they're experiencing in the courtroom, and sort of increase the consistency in which you can help folks navigate the process. So again, I've already sort of asked for some chatting in about this, but I have some kind of specific questions around this. We have a couple more minutes. But just what you think is confusing, and what are some strategies you can think of to overcome these challenges. This is kind of these are kind of hard questions to have over a webinar, but I wanted to put them out there anyway, so that you can all continue to have these conversations. So continue to think about what's confusing to clients, think about the ways that clients challenge you, and then think about some kind of high-performing enhanced strategies to overcome these challenges and increase compliance, engagement, improve public trust, all the things that we've been talking about. So, if folks want to kind of type in any last ideas, that would be great. But really, these questions are meant to kind of go back to your own communities, to your own practices, to your own courthouses, and really have these conversations with the other stakeholders and with your colleagues, to think about ways to, be able to deliver procedural justice consistently, and ways in which that can help support self-represented litigants. So just some closing thoughts. Procedural justice promotes public confidence in and respect for the system. So I think this is a worthy aim. In delivering procedural justice, we need to walk in the shoes of the client or in the shoes of the litigant, thinking about, all of the circumstances in which they might find themselves in, thinking about all those challenges we talked about, education and trauma and bias. And then that procedural justice is really mutually beneficial. If we can systematically help folks access our system better, then it is going to make our jobs easier. It's going to increase engagement. They're more likely to view the court as a resource. They're more likely to comply with court orders. They're more likely to comply with the agreements that you come up with and draft. And then also just that we can't always increase resources, but procedural justice principles can help really maximize what you have, and doesn't take a lot of money or resources. So obviously, if you're thinking about developing high-level resources for self-represented litigants, as Darren talked about, and the guide that he shared with you, those are things that may take some more, but some more resources and some more time and buy-in from the court and all of that. But in thinking about just your own practices, it's actually really simple to kind of just change some of your approaches, and kind of adjust some of your interactions with folks, to figure out how to kind of maximize how you can help folks to navigate the process. We've got a final chat here. Sorry, I'm trying to access it.
Hi, Kate. It's Susan. That was just me again chiming in, I think.
Yeah, yeah. Okay, I'll read what you wrote, or unless you want to say it.
I mean, I just think like part of what's frustrating is sometimes we, well, what did I say here? Oh, managing expectations of clients in the beginning is really important. I think sometimes clients expect things to happen that, you know, just we can't make happen. Like they want the other side to have no custody, or, you know, just explaining like how difficult the court process is before people jump in, I think helps with the procedural justice stuff. And I really do think that like us talking about these issues and trying to educate the court a little bit more, and if people across the state have help centers like we do in Philly or anything for self-represented litigants, making that information accessible and easy to read and understand is super important.
Yeah, thanks for that, Susan. Absolutely. You know, as I sort of alluded to throughout the presentation, there are going to be a lot of things you can't control and a lot of like frustrations and challenges with the system that you really can't, you know, do much to change. We like to think we can do some things, but I know how frustrating it is to, you know, work within a system that has so many challenges, and is so overburdened and lacks resources and all of those kinds of challenges. But these are really things that you really help mitigate. I'd like to say that it's mitigation as opposed to, you know, fixing anything for folks who are accessing the system, but really just helping to change their experience, shift some of those perceptions, be more helpful to folks, helping them navigate the process. All these things can really kind of mitigate what is otherwise a really, really challenging process for anyone. So thank you. We are out of time. Thanks everyone for joining, and feel free to reach out if anyone has any questions. You know, we provide technical assistance on these issues and are really always happy to talk with you about how you might implement some of these principles or strategies in your own communities.
Thank you very much, Kate, for this presentation. We really appreciate it.
Thank you. Have a good day, everyone.